I'll take the opportunity to welcome in my guest for this hour. Joining us, criminal defense attorney Sam Bassett. Sam, thank you so much for joining me on the program. And I really want to get your input as to the job of the defense here. It's a difficult one. There is a video there that is very damning, very difficult to get past. We're hearing emotional testimony from folks who actually showed up to the scene. And it seems to me that the defense is going with this sort of hybrid, this provocation, this heat of passion defense, combined with, my guy was a soldier, you don't want to leave him on the field, and also battered spouse. It's like kind of this hybrid defense. What do you make of it? And do you agree with my assessment?
I do agree. I think you have to work with what you have as a defense attorney. And I think you have the combination of factors here that provide some level of a defense for the defendant in terms of his mental state at the time of the shooting, what explains that, what type of emotions were involved, and in addition, what is his career, how has his career impacted his mental health? Obviously not rising to the level of insanity or incompetency, but you have to be able to combat the charge with some sort of mental health issues.
It goes to this idea, and he used the word of snapped, you know, that he snapped at the time. And one of the things that's important about these eyewitnesses, and this is my question, you have a case where you have a video, you look at the video, the jury can make a decision. So, you know, how important are these eyewitnesses? And I think they're very important when we talk about a defense of somebody snapped, because they're telling us all about his actions both before and after the incident, which will give plenty of insight into whether he snapped.
And that is a problem, you know, for lay people to observe somebody's behavior and what they do before and after the act in question definitely impacts the assessment of whether or not these issues that the defense will raise are valid.
Yeah, I would agree. All right, Sam, stand by, because it looks like they're back in court right now. I want to bring Sam Bassett back in, criminal defense attorney. One of the issues that's going to come up here, Sam, is that this witness showed up in court with a notebook, and he had an outline of what he wanted to talk about on the stand. Tell our viewers how that plays out in court and if that is or isn't a problem.
If the witness has a notebook with them when they're testifying, the attorneys who will examine him have a right to access that notebook for purposes of direct or cross-examination. It also would shed light on whether or not the witness is overly rehearsed and has decided his testimony based on the notebook or based on his memory and the truth. So it's very unusual for a witness to bring in a notebook and take it up to the witness stand, for sure.
Yeah, and he had a lot of long narratives in his answers. It gave me the sense, it wasn't surprising to me that maybe there was this notebook. All right, it looks like they're ready to address that issue, a number of other issues as well. All right, while they sort things out in the courtroom, I want to bring back in my guest quickly. Still with us, criminal defense attorney Sam Bassett. Sam, I want to get your thoughts on the handling of that notebook. Again, as I mentioned earlier, I didn't think it would be that much of a big deal, considering it was only 9 pages. There was some outline in there, but I thought the defense made some hay of it. I'm not sure it was to good effect. I want to get your thoughts.
You know, as a defense attorney, you have to walk a fine line between attacking the witness versus doing your job and cross-examining a witness. He was walking that line fairly well, I think. He may have gone a little bit over the top, but I do think that that's why we always want those notes when we're cross-examining a witness, because we want to see if there's anything in there that's external to just memory or things such as that, and we want to see bias, evidence of bias, or any comments that would indicate that the witness may not be as credible as he may seem. So I thought the defense attorney did a pretty good job, but I do think maybe he stepped over the line a couple times. The witness seems fairly sympathetic in his demeanor, so, you know, I'm not sure a lot of damage was done, but it was interesting. For sure.
Yeah, I mean, and that was my point. It's like there were times there where I just felt bad for the guy. I'm like, it was clear. He said, look, I got a bad memory. I'm taking these notes. I think the implication was, to your point, that maybe he was basically reciting things that the state told him to say. I'm not sure that that was terribly hurtful to the state's case, but I think that's where he was going, right? At the end of the day, he wanted to make clear that it was possible that this witness really had trouble remembering and was basically reciting what the state wanted him to say.
I agree. I think he made a little bit of a point there with that. Obviously, it's, in my opinion, a witness like this, you get in and you get out on making your point. So it can be argued whether or not he went too far or not, but I think he made a small point.
Yeah, I'm with you. I think with a witness like this, not sure it's too important to the facts of the case in terms of what you're trying to accomplish. As a defense attorney, you get in, you get out. He's sympathetic, as you said. I might have just let it go a little bit more. But anyway, we're going to take a quick break here, Sam. When we come back, we'll have more from inside that courtroom. So keep it here on Court TV, your front row seat to justice. Let's bring back in our guest, still with us, criminal defense attorney Sam Bassett. Sam, just as quick background for our viewers, there was this ongoing civil suit, you heard him mention it, regarding some inmates who are claiming that court personnel are having sex with them, forcing them to have sex in the judge's office there, in his chambers. And he was about to be deposed. He's claiming here that probably there was a threat to him. He was worried about, folks were worried about what he was going to say in his deposition, and also that he perceived these threats, whether they're true or not. First and foremost, I want to ask you, what is his attorney doing putting this out there this way at this point as they move forward with this case?
It's a big strategy decision, I think, for an attorney to get into the media possible defenses and facts that you're going to use in your case. I'm a little more cautious than that. I think one of the few things we have as defense attorneys is the element of surprise, the element the other side can't plan their prosecution without knowing exactly where we're going with our defense. Interestingly, he has laid out a lot here. So perhaps his strategy is to influence some of the players that are making the decisions about the case to work out some sort of a plea bargain or a lesser sentence. I'm not sure what the strategy is. It's something I would be cautious about.
Sam, I got to say, in this day and age, especially in this particular instance, where this is a case that has gotten national attention, there's an actual video out there that just about anyone who's interested in the case has seen. Controlling the narrative would seem to be very important, and that's what it seems to me what he's trying to do here.
I think so. I think there's so many, it's such a highly publicized case in that area especially. He's got to be trying to influence, if not the decision makers on any possible settlement of the case, perhaps prospective jurors as well. I don't know. It's certainly an unusual posture to take, in my opinion.
Yeah, new day and age in the annals of criminal law, for sure. I want to talk about the defense that he put out there. He made pretty clear there were three options: that there was a threat that he perceived and it was real, it was objective; that there wasn't a threat and there was some mental health issues; or this hybrid, where perhaps there were some threats out there, but he also had some mental health issues. What do you make of that defense under the circumstances?
Well, that does make some sense. Not knowing the specific nature of the threats that he's talking about, it seems like he felt like his family, his wife and his daughter, could be threatened in some way by the goings-on in the case and what had happened in the judge's chambers, and that he misperceived those threats or greatly exaggerated them in his mind, and it caused him to lash out and do what he did. So it all makes some sense to me. But again, I don't know why he's laying that out now exactly, but it does make some sense to me.
So where does that leave him in terms of these murder charges? Let's say, in fact, there was this objective sense that there were these threats out there he was worried about, and the way he put it, he thought his wife and daughter were in imminent danger. Let's say that is the case. Where does that leave him in terms of these charges, the murder charges in this case?
Well, I mean, you could go so far as to say defense of a third person, but using deadly force and the way it was used, defense of a third person would be a real stretch. More likely, more of a manslaughter type theory, where he was acting under sudden passion or under some sort of mental duress that inflamed his passions and caused him to take the judge's life. I don't know, but that's what comes to mind when I hear that.
Yeah, probably trying to drop that murder to maybe a manslaughter, heat of passion type situation, or even some sort of mental health defense. The last thing I'm going to say about this particular instance is that, he's talking about fear for his family, but yet the family's not in the room, and I'm not even sure how much this judge was involved. Why he targeted the judge would seem to be an issue as well. Quickly, I only got about 20 seconds.
Yeah, I agree. I mean, I think it may be also a sentencing issue he's throwing out there to try to reduce the sentence if he is convicted of the murder. Hard to say exactly.
Yeah, exactly. We'll have to wait and see. Of course, we'll keep our folks updated on it. Sam Bassett, thank you so much for joining me this hour.